Hi there, everybody. Good afternoon. My name is Chris Justice. I'm an employment lawyer with Samfiru Tumarkin, and I'm here to hopefully answer any questions that you may have with respect to any workplace-related issues that you're experiencing. Whether they have to do with issues before entering a specific employment relationship, while working for your employer, or perhaps issues that have arisen after your employment relationship, please do send in some questions and I'll try my best to answer everything that I can. I'm personally operating out of our Toronto office, but we do have associates that work across the country. So, depending on your particular area and your particular issue, you can definitely visit our website, employmentlawyer.ca, and look into each of the associates and others available to hopefully provide you with the best advice possible. So before we get into some of the questions today and throughout today, I've also put together a list of, I guess, what I'll call tips or some key considerations that I myself have to deal with on a daily basis as a lawyer. And my hope is that by providing some of these tips and considerations for you to keep mind of, that you'll be in the best position possible should you actually have to take any form of legal action. And so hopefully I'll get through as much of my list as possible, but it'll just depend on how many questions I get from all of you as well. So the first thing I've put on my list is pretty straightforward. It's a general point, but that is to get legal advice before making any significant decisions when it comes to your employment. So again, whether this means having a contract reviewed going into your employment relationship, whether it means discussing something with a lawyer about issues you're facing while working for the employer, or perhaps on your way out if you've been given a severance package, if that means talking with a lawyer and ensuring that what you've been given is fair and reasonable, it is always very recommended to get legal advice, because the last thing you want as well is to take a certain type of action ultimately to your detriment, and then sort of discover this after the fact and it being a much harder task to overcome. So with that said, before I get into some of the other items on my own list, I do realize we've got some questions coming in. So I'll read one of them. This question is from Sanam, and Sanam is asking or saying that the position has recently changed and I'm working on a lot of on-call hours, but I've not received additional pay for the extra work. Can my employer do this? So that's a good question. Certainly, when it comes to changes to your employment, you definitely want to get legal advice. That was one of the things I mentioned, something that can happen during your employment before simply agreeing to what it is your employer is doing. And if you're an hourly employee, for instance, and you're having to work a lot of additional hours, then absolutely you are entitled to additional pay. And that pay may also be overtime pay, for which you might get time and a half for. So depending on whether you are an hourly employee or a salaried employee, that could affect things. But the general point there is that if your employment situation is changing, regardless of who you are, and you're having to put in a lot more time than you initially understood or agreed to, that's, again, definitely something that you would need to consult with a lawyer on, and a discussion that you'll probably have to have with your employer to make sure that either you're getting compensated appropriately for that extra work, or if not, to establish whether you're even agreeable to the changes that are being proposed. So thank you very much for your question there. I've got another question from Razor Sharp, and Razor Sharp is asking, how do I know if my employment contract is not a good one, and how do I go about asking to change it? Okay, so that's a fairly general question. In terms of wondering whether or not your contract is a good one, Perhaps by that you mean, whether you're being paid appropriately, in which case, if you've already signed a contract with certain compensation details, it could be a difficult demand to approach your employer and ask them to change it. Though when it comes to any changes, what I always say is that if you've got an idea of what changes you want and why, it's good to think about that and the basis for the change, and to approach your employer and see. But it will really come down to the change itself, whether the employer is agreeable to it or not, whether there's something in a contract that you might have signed that in some way prevents you from asking for that change, or at least putting you in a position where you can get that change to be accommodated or accepted. But that's another reason why before you sign a contract with a company, you should get legal advice, because that way a lawyer can go through the contract with you and identify all the areas of concern, whether those areas involve issues of compensation, whether you're worried about there being a non-competition clause contained in your contract, or whether you're worried about maybe what you would get in the event that the company were to terminate your employment. Always much, much easier, of course, if you go in knowing exactly what the contract means before signing it, as opposed to trying to change the contract after there's already been an agreement. But having said that, and this goes for anyone listening, if you would like to ask a question or talk about your situation in a bit more depth offline, and maybe just directly with a lawyer at our firm, then that's absolutely something that we're happy to accommodate and discuss further. So I'll wait for some more questions, but in the meantime, I'll go back to my list of sort of some key tips and considerations to think about. The second one I've got here is put things in writing. This is a general tip I find in my practice. A lot of times there becomes an issue where an individual comes to me with a number of concerns of which have maybe events or incidences that they've experienced over many months or years that they never really took note of before, that they never sort of put in writing to their employer. And it can become a lot more challenging to sort of after the fact go back and try to recall what exactly might have been said, what sort of incident arose. And a lot of times, if you don't put things in writing, then people's memories fade. The employer may have a different version of events. And so this is sort of a practical tip, putting things in writing, because while you may not go into an employment relationship thinking that there's going to be an issue, or thinking that you may have to take some sort of legal action, it's always nonetheless good to have that foresight and prepare yourself in the event of the worst case scenario. And if you've properly documented things before speaking with a lawyer, or you've made notes yourself as you've experienced various things in the workplace, that's going to not only give you a better idea exactly of what was communicated to you or what did happen, but it will also, in many cases, go a long way to sort of adding credibility to your side in a situation that could result in a battle of he said, she said, which can be inherently a very risky path to go down. So that's my advice. Put things in writing. If your employer is changing the terms of your employment, going back to Sonam's question, and you object to the change, then it's always important that you object to the change in writing, so that, again, later on down the road, if that becomes something that's in dispute, you've got an email or a note of some sort to fall back on and say, well, no, I did refuse or object to that change. And then that won't be a change that later on the employer, may be able to argue you condoned or accepted. I've got another question that's just come in, so I'm going to stop my list. And this question comes from Paul Sergalis on Facebook. And Paul is asking, could I sue my former employer for punitive damages for dragging out my full and final settlement to now almost 2.5 years? And first of all, thank you for the question, Paul. Generally, I would need to know a bit more information about your particular circumstance. So forgive me, but I may make an assumption or two here. But it seems to me like you have, I guess, in a way, agreed to settle a matter with your former employer, and despite there being an agreement, perhaps in writing, they haven't complied with the terms of the agreement, that, the terms that might be in your full and final settlement. So if that's the case, then absolutely, you could very well have recourse. If there's been an agreement in place and the employer has failed to comply with the terms of that agreement, then you could certainly very possibly go after that employer for breaching the terms of the employment relationship, or I guess the employment settlement, I should say. And so that may not only involve the employer obviously being on the hook for what it is they agreed to in the settlement, but simply for the fact that they breached the terms that they agreed to and sort of delayed the matter by as long as you've stated, 2.5 years. To me, that seems very egregious and could very well result, as I say, not only in just them complying with the terms that they agreed to, but also potentially being hit with extraordinary damages, which, as you pointed out, may include punitive damages. It's not an easy road to go down, so you really want to make sure that you have a strong case, but absolutely. And depending on the circumstances, there is recourse for those who are in a situation like yours where the employer is essentially reneging on the deal. So hopefully that answers your question, Paul. But again, if you've got any further information or want to follow up with me directly, by all means, please do so. So I'm just going to go back to the list that I created of tips and considerations. Number 3 on my list is another general point, but very helpful. Understand the role that you have and the terms of your employment. As an employment lawyer, one of the biggest issues I come across is or are situations where an employee, he or himself, they're just not sure exactly what the terms of their employment are. Whether it has to do with how a commission structure works, or how bonuses are paid, or actually what their primary duties and responsibilities are, what their title is. I mean, there are a number of situations that have arisen in the past, in my experience, where this has been the case. And the issue with not being clear as to what your job is that the employer can more easily or more likely change around the terms of your job. And because you don't have a solid idea of what your job is, it's going to be hard for you to make an argument that those changes are significant. Whereas if you are very clear as to how you're supposed to perform your job, what you're exactly responsible for, how much you're paid, and how that gets calculated, then there's going to be less issue down the road when, let's say, for example, you're trying to argue you're owed a number of commission payments, and the employer, your former employer, is saying that, under the commission plan, you're not entitled to those payments. And, in these cases, a lot of times there just simply isn't a lot of clarity on the employee's end. And that can be, damaging to a potential case they have. So again, going back to the first point I raised, or rather the second point, put things in writing. Make sure that you've got a job description list. Make sure that you understand how the commission structure works, if there is one. Make sure you understand what the criteria is for how the bonuses are calculated and whether they're discretionary or not. Because again, you don't want to leave it until after the fact, and then you're left where you're in a position arguing that you're owed a bunch of money, and the employer is saying that, no, that actually isn't the case, and these are the terms of your employment. So definitely transparency is great. And again, getting it in writing is absolutely critical. I've got another question that's come in from Arlene from YouTube. Arlene is asking, can I negotiate a better employment deal more vacation time, reduced hours in the context of an entry-level job. And what I'll say here, and this kind of applies for any position, is that you can negotiate anything essentially that you want. Whether or not the employer or the company will agree to what you want is an entirely different question. But if you are an employee and you're considering, for example, starting a new job, and you may have questions about wanting more vacation time or wanting to work a reduced number of hours, first of all, that may be something your employer will consider. And so there isn't any harm in approaching your employer and making that request. And if you've got a good reason for doing so, like for example, if you want to work reduced hours because you have childcare commitments or because of some other legitimate reason, then that can also help probably put you in a better position to get what it is you're asking for. And in some cases, the employer may even have to accommodate that, in any event. It kind of depends on, when you say, can you negotiate a better deal, whether we're talking about, before you sign a contract or while you're already employed there and you kind of want to change, some terms of your employment. So definitely you can negotiate a better deal. You may want to get a lawyer involved. And of course, the employer has to satisfy the minimum obligations it owes to you under law. But as far as anything above and beyond that, it may also come down to how badly the employer wants you as well. So, and Arlene, thank you for clarifying that you're talking about before going into the employment relationship. So it may be more difficult to negotiate everything you want if it's an entry-level job. And I only say that because depending on how much the company actually wants you as an employee, that is also something that could give you as an individual leverage to get a better deal. Whereas if it's an entry-level job that presumably a number of people are interested in, and you want a better deal than perhaps someone else is willing to accept, then it could result in you not getting the job, or it could result in the employer simply telling you that they can't really give you any better terms. So the extent of the leverage that you have is an important consideration, but there's certainly no harm in asking. I always think that if you have an idea of what you think you're worth or what compensation you'd like, negotiating is never a bad thing. And the worst case scenario, you're just told, sorry, we can't make it any better. And then you're left in a position where, you can just consider whether to accept it or not. So hopefully that answers your question, Arlene, but thank you very much for sending one in. Razor Sharp has another question from YouTube, and the question is, does starting a new position affect my ability to claim constructive dismissal? So again, I'm going to speculate a bit here in what you mean by that, but let's say you are working as, let's say a lawyer. Let's say you're working as a lawyer, and at some point the company comes to you and says, we can't have you work as a lawyer anymore. We want you to be an assistant. That's going to be viewed, of course, as a clear demotion. And as an employee, you're going to have the ability to choose ultimately whether you want to accept that new position or not. If the position itself is a clear demotion, for example, then there's no strict requirement that you accept the position. And you can, by all rights, object to that and simply ask to continue in the job that you had or something similar. And if the employer doesn't want to give you your old job back and is insisting that this is the only position available for you or to you, then you would, generally speaking, have a good claim for constructive dismissal. But if you end up accepting that position, that's a demotion, for example, it's going to be harder, much harder for you then to later on claim that you were constructively dismissed, because a court is going to view you as having, essentially accepted the role. And that's going to then form the new terms of your employment. So very, very important, if you're being put in a position where someone is telling you that your role is changing and you're wondering if you have a constructive dismissal claim or not, definitely don't accept or agree to anything in writing before consulting with a lawyer, because you then could be deemed to be in that new role, and then that could have further ramifications on you going into the future. So again, razor sharp. I hope I answered your question, but if you'd like to provide any further specifics, by all means, send that my way. So I've got a bit of a break in terms of questions, so I'm just going to go back to my list. I've got number 4 as being, don't assume that the severance package you're offered is fair. And again, a lot of these tips and considerations are fairly general in nature, and actually things that you can get further information and details on through pocketemploymentlawyer.ca. But yeah, do not assume that the severance you received is fair. I would imagine, first of all, for every individual that comes to me asking about whether or not the severance package they've been given is fair, there's probably 8 or 9 or 10 other people who just accept it, without consulting a lawyer, thinking that it's fair and reasonable. And maybe the severance package says that the company is giving you not only what they're required to do so under law, but extra amounts on top of that. You may think, looking at that is a fair and reasonable offer. They're giving you more than what the law says you're entitled to. But just understand that it is very rare that an employer's first severance package or offer to you is going to be fair and reasonable. And it's absolutely essential that in many of these cases, you consult with a lawyer to make sure before, again, signing off on anything in terms of a release. I've got another question here from Restream, and it's a question from Morgan. Morgan is asking, how long does a severance entitlement take to be settled usually? So hard for me to give you a complete answer there. There's of course a range as to when cases can settle. For example, if you've been terminated and you've been given a severance package, and in the hypothetical I just raised earlier, the severance package is not enough, you may come to a lawyer and have a lawyer try to get you a better severance package. Now, if you can avoid a lawsuit and you and the company can come to an agreement on a better severance package without the need for litigation, then it could easily be the case that you can resolve your matter within a couple months, if not a little bit longer than that, but no more than that. Now, if you have to commence a lawsuit, however, it will depend on how complicated your matter is. So, of course, if your particular matter not only involves issues of whether the severance package is fair, but also has a number of issues that may involve bad faith allegations, discrimination, more what I'll call contentious issues that the employer usually pushes back on much more aggressively, then you could find yourself in a lawsuit that lasts easily over a year. And on the other hand, there are lawsuits that don't last that long and that can be settled within 3 or 4 months' time. So yeah, hard to say. Completely depends on how complicated your matter is. But if it's just a straightforward question of how much severance you should get, then it shouldn't take that long. Although, having said that, now with COVID and the pandemic and with everything kind of switching remotely, that's another practical reality that I've told and will continue to tell my clients, as far as it kind of creating a bit more of a backlog in terms of the courts are concerned. So with the pandemic, there's just a bit of an exception going on, and it's a bit more difficult to determine that. But even with a lawsuit, a lot of straightforward cases settle within 3, 4, 5 months. So yeah, just depends on the specifics of the case. But again, if you have any further inquiries, by all means, send another question or feel free to get in touch with the lawyers directly. So I'll wait for the next question, but I'll go back to my list. The last one I mentioned was not to assume that the severance package that you'd be given is fair, and to definitely consult with a lawyer before accepting anything. The next point I have here is, the note I have is, recognize that your severance entitlements are in part dependent on whether or not you find another job. So a lot of people that I come across, a lot of people that I speak to on a daily basis believe that because they've been with a company for, let's say, 20 years, that they're owed, a year's worth of pay or something, very significant. And while there are definitely certain minimum entitlements that you will get as a terminated employee, no matter what happens in the future, your potential maximum entitlements are still subject to you going out and finding work. So that's another practical reality and issue that I come across a lot. So, for example, where I have a client who was let go, but was able to find something comparable within a few months, that person's case or claim, as far as a lawsuit is concerned, for example, is going to be a lot less than someone who actually requires a year or longer to find work. So that's just sort of a general, a lot of people may think that, regardless of whether or not you find a job, you should get, a year or 2 years of pay. It's just, not quite the case and dependent on the situation. I've got some more questions that have come in though, so thank you for that. I've got a question from Fredette. It's through YouTube, and the question is, I was recently let go from a contract position short of the completion date. Am I entitled to any severance? So thank you for the question. This brings into issue the idea of a fixed term contract. So most contracts are of an indefinite nature, or at least a lot of contracts are of an indefinite nature. But some contracts actually say that you are to work, a given period of time, whether it's a year, 2 years, 3 years, 4 years. And these can be a bit different in the sense that, let's say you have a year-long fixed-term contract and you've worked 6 months of that year and your employer lets you go. And by that point, you only have 6 months of service with the company. Under a term of indefinite employment, under a contract of indefinite duration, you as a 6-month employee may not get that much severance. You might get a month, 2 or 3. But depending on what the contract says, and so, having to look at the contract will be important. But depending on what the contract says, if you're let go halfway through a fixed term, you potentially could have a claim to be paid out the balance or the remainder of that term. So in the hypothetical I raised, where you've got a year-long contract, half of which you've completed, and then you're let go, you could potentially make a very solid argument that you were to be paid the remaining 6 months. So Fredette, depending on your situation, you could either be entitled to the balance of what's left over in that term of yours. You could also be entitled to severance under the common law, which would depend on your age and how long you've been there in total and the position that you held. Or there may also be something in the contract that limits you in some other way. So in all likelihood, you are entitled to severance, but it'll be a question of how much. And the starting point would be to look at the contract and figure out what it says, if anything, about termination, if you are, particularly if you are let go before the end of that term. So hopefully that answers your question, Fredette, but thank you in any event for reaching out. And I've got a follow-up question or comment from Arlene from YouTube, and she's asking, can my current employer expect me to find a babysitter instead of using my, I think you just meant subsidized childcare? It will always cost more for private care. So I guess it depends, Arlene, on the context that you're raising the question in, but it'll just come down to what the most reasonable accommodation is. So if your employer is telling you to do this or to do that, and it would result in an additional cost to you, I guess one question would be, can the situation be accommodated in some other area? So for example, if the issue is with the hours that you're working and you need somebody to look after a child because your employer is insisting that you work a specific set of hours, I would say that you should explain to the employer why those hours don't work and why that will result in some additional costs to you. If the costs are relating to private care, caretaking. So I would explain to the employer, what burden you would suffer essentially as a result of whatever it is the employer wants, and ask for accommodation. If you can get a set of hours, for example, that fit best with your schedule and your employer's on board with that, then absolutely work towards that end. And if your employer pushes back or refuses to give you hours that work with your personal circumstances, it may be that you have a valid claim and that they can't do that, or that they're being unreasonable. But it just kind of depends on what the employer's reasoning is for why they're doing what they're doing. It's always looked at from the lens of the objective person. What would a reasonable person do in the circumstances? And so, you're saying that you're being accommodated for now. But if you do get the sense that your employer is gonna be changing things on you, then you need to be clear as to what the changes are, and I think at least attempt to seek some accommodation and find out what they say in response to that, because they may be reasonable in refusing the request, or they may not be, and then that could entitle you to potentially significant severance. I've got another question in from Susan on Facebook. Susan's saying, a number of us were laid off due to COVID last March. Many people were called back, and a number of them had their pay rate reduced upon return. Can the employer do that? So again, this is a matter of the terms of your employment changing. And there may be a legitimate basis for the employer asking that these people take a pay cut, particularly if the business has been affected by COVID. However, that doesn't necessarily mean the employer can do that. Depending on how big of a pay reduction it is, even if the rationale is legitimate, you as an employee may still have an option to either accept it or reject it. Of course, if the employees that come back agree to the pay reduction, then the employer can do that. But if the employees object to the pay reduction, then the employer cannot necessarily force that change on them. And if it's a substantial reduction, as you've mentioned, Susan, then absolutely, you don't want to necessarily be agreeing to it, at least first without consulting a lawyer. Now, the question is, if you object to the reduction, what's your employer going to do? Are they going to put you back on a layoff? Are they going to terminate your employment? Are they going to let you come back with a greater rate of pay? That's ultimately the question. And depending on how the employer responds to your objection, you may or you may not have a claim. But certainly if you agree to it, or you come back and you don't raise any concern whatsoever about it, that could dramatically affect things, especially if you haven't been told when the reduction is going to end. And that may be another thing that you would want clarity on, is if you're going to agree to a pay decrease, maybe you agree only partially to a certain period of time. Susan, you're following up with another question. You said you were told that you were permanently laid off. So the phrase laid off is often confused with termination. So when you say that you're permanently laid off, as opposed to being laid off on a temporary basis, then you could very well be in a situation where your employment has effectively ended and you could be entitled to potentially significant severance. So I think if you have been told by your employer that you are permanently laid off and that there's no recall date, that's definitely something that you should talk to a lawyer about and get some advice before taking any further action. I've got another question here that I'll take before we wrap things up. I realize I got through some of my own personal list, but as I said, I'm happy to answer as many questions as possible. And it's from Arlene, I guess as a follow-up. My employer has recalled some employees, but not all. Are the ones that have not been recalled considered to be terminated? Not necessarily. The question would be, why is it that some were recalled back and others weren't? Because if you're, let's say, a salesperson and you're laid off, and you're one of 10 salespeople that are laid off, and then they recall back 9 of the other 10 salespeople, and you're the only person left on a layoff still, then that's very different than if you are in a position that no one else has within the company, and you're laid off. So generally speaking, layoffs are actually not acceptable according to the common law. So even though there have been some recent revisions to legislation, and even before the revisions were made, a reference to layoffs in the legislation, as an employee, don't assume that your employer actually has the right to lay you off without your consent. And if you're in a situation where you've been laid off due to COVID or any other reason for that matter that you don't consent to, especially if you've been with a company for a long time, you could very well be in a position where you've been terminated and you're entitled to severance. So don't feel like you need to wait around about, are they going to recall me back or not? Take some initiative now, get in touch with a lawyer. Absolutely. Get in touch with our firm, because you may have a number of options and you don't necessarily want to wait and let time pass and then have that held against you. But with that said, we are nearing the end of today's session. So I do thank you all for your questions. I hope that I was able to answer them as good as possible. Again, if you have any follow-up questions, by all means, feel free to contact me or any other associate at our firm directly, and we'd be happy to help and at least give you some more information. Again, I want to thank everyone for tuning in, asking the questions. Look forward to future events, and absolutely get in touch with us if you need any further advice. Visit pocketemployer.ca. I mentioned this beforehand, and it will have a lot of information on some general issues that are often experienced in the workplace environment. So take a look at that for sure. Otherwise, do get in touch with us, employmentlawyer.ca. And otherwise, I hope you all do take care. Thanks again for tuning in, and all the best. Take care. Bye for now.